Get ready. Exercise number 39. Start. The apex court in Ranjit versus Sri Mohan held that the burden on the accused is only to raise a probable defense. Stop. In this case, the defense is vague and unsubstantiated. Stop. Accordingly, the accused is found guilty and convicted under section 138. Stop. He is sentenced to undergo simple imprisonment for 6 months and is directed to pay compensation of rupees 10 lakh to the complainant under section 357 CRPC. Stop. Para. This is a petition for divorce filed under section 13(1) of the Hindu Marriage Act 1955 by the petitioner Mr. Saurabh Chawla, seeking dissolution of marriage on the ground of cruelty by his wife Mrs. Naina Chawla. Stop. The marriage between the parties was solemnized on 25th March 2019 as per Hindu rites and ceremonies. Stop. The petitioner alleges that the respondent has subjected him to constant mental agony, insults in front of relatives, and false accusations affecting his professional reputation. Stop. It is further alleged that the respondent filed left the matrimonial home without cause and refused to resume cohabitation despite several attempts at reconciliation. Stop. The respondent denies the allegations and claims that it was the petitioner who harassed her and that she was forced to leave due to unsafe conditions. Stop. After evaluating the pleadings, evidence, and cross examinations, the court finds that the petitioner has established mental cruelty as recognized in V. Bhagat versus D. Bhagat, where continuous humiliation, taunts, and public defamation were held sufficient for granting divorce. Stop. The petitioner is entitled to relief. The marriage between the parties is dissolved by decree of divorce. No maintenance is claimed. Stop. Parties are directed to comply with terms regarding property and child visitation rights as per the settlement agreement on record. Stop. Para. This claim petition under section 166 of the Motor Vehicles Act 1988 has been filed by the claimant Mr. Anil Rathore, seeking compensation for injuries sustained in a motor vehicular accident that occurred on 8th April 2024 at approximately 6:30 pm near Rajnagar Extension, Ghaziabad. Stop. The claimant alleges that while he was riding his motorcycle bearing registration number UP 14BX 4785, a speeding car bearing registration number DL3CA2210, driving rashly and negligently by respondent number 1, hit his vehicle from behind, causing him to fall and sustained grievous injuries, including a fractured femur and spinal compression. Stop. The FIR was lodged on the same day and the claimant underwent surgery and prolonged treatment including physiotherapy. Stop. The claimant was 32 years old at the time of the accident, working as a gym trainer and earning a monthly income of rupees 35,000. Stop. The respondent number 1 is a registered owner of the offending vehicle and respondent number 2 is the insurance company. Stop. The insurance company, in its written statement, denied liability on the ground that the driver was not holding a valid driving license at the time of the accident. Stop. The driver, however, produced a copy of his driving license issued by the Transport Department, Delhi, where was verified and found genuine. Stop. During the proceedings, the claimant produced certified copies of the FIR, site plan, injury report, disability certificate showing 45% permanent disability, treatment records, salary certificate, and oral evidence confirming loss of earnings. Stop.